Welcome back to the Florida Real Estate Sales Associate Pre-Licensing Course. Unit 5, the real estate brokerage activities and the procedures. This unit is going to talk about the influences that affect the day-to-day operations of a real estate brokerage. Statutory requirements, spell out the office and the branch office regulations, rules governing the signage, the advertisements, the escrow deposits, the record keeping, and the overall conduct of the business of the brokerage. The broker's role, a very important role of playing as an expert when it comes to handling the escrow funds, fees for the rental property, and information, rental lists, and so forth. Also, we will talk about compensation in detail. We will also talk about the business entities that may be registered to operate as a real estate brokerage. By the time you're done with this unit, you should be able to identify the requirements of a broker's office, explain what determines as a temporary shelter and whether it's a requirement for registration or not. We will also talk about the requirements for the signage regulations, requirement of the advertisement regulations, the term immediately when it comes to escrow deposit. We will go over that. We will talk about 4 settlement procedures which are available to a broker in terms of in the event there is a escrow dispute. We will also talk about the rules regarding the advertisements, the regulations regarding the lien rights for unpaid sales commission, and the various type of organizations, business entities that may be registered to practice real estate. So let's move forward. In the state of Florida, it's a requirement that all brokerages must have an office that should be registered with the Department of Business and Professional Regulations. Now, there's a list of requirements, minimum requirements that must be fulfilled in order to meet the guidelines. The brokerage office must have at least one enclosed room of a stationary construction. Offices must be registered with the DBPR. Offices must provide privacy to conduct negotiations and closings consisting of at least one enclosed room in an office building or in a building of a stationary construction. The books and the records, the transaction file, etc., must be maintained at the office. It must be readily accessible. Now, offices may be in the broker's residence, but the broker has to verify with the HOA and the zoning requirements. Sales associate may not open up their own office. Okay, sales associate cannot open up their own office. Sales associate must be registered from and work out of an office maintained and registered in the broker's name. Okay, so broker. So if there is an office that a salesperson is working out of, it has to be registered in the broker's name. Branch offices much. Now, brokers, there are many brokerages who have operations in multiple locations, so they are allowed to register each branch office. The branch office is not transferable to another location. Now, temporary shelter, not a branch office, unless and until there is sales associates that are permanently assigned or sales transactions are closed at that location. And as we move forward, we will talk about a little bit more in detail about what qualifies as a temporary shelter. So there are many brokerages that operate from multiple locations. So Department of Business Regulations allows real estate brokerages to register multiple locations as their branch offices. Now remember, the branch offices licenses are not transferable to another location. Talked about in the beginning about temporary shelters. So a temporary shelter is a classic example is a in a subdivision where the broker is responsible for marketing of a particular subdivision or a bunch of properties. Um, the sole intention of that shelter is protection of the consumers and sales associates. Now, if that temporary shelter has designated sales associates which report there on a daily basis and conduct sales transactions, which means write offers, then that location has to be registered as a branch office. Other than that, there is no requirement for a registration of that temporary shelter. Signage. Now, you might see some questions on that in the exam as well. Active real estate brokers must display an official sign on either the entrance of the interior of the entrance of the principal office or all branch offices. Active real estate brokers must display a sign either on the exterior or on the interior of the entrance of the real estate office. The signs must be easily observable, easily readable by anyone who is entering into that office. The sign must contain the following requirement information: the trade name, if it's being used, the broker's full name as registered with the Department of Business and Professional Regulations, and then the words licensed real estate broker, or in short, LIC, real estate broker. These are the three key required information. You want to put your phone number, you want to put any other information, it's up to you. But the state requires these three pieces of information that must be available on all office signage of the principal office or any branch office of an active real estate brokerage. Now, it's optional that the broker may choose to put the name of a sales associate or broker associate, but it's not a requirement. Uh, Now, if included, they must not appear as misleading or false or deceptive or fraudulent in any way, shape, or form. If you look at the textbook, there is a figure 5.1 on page 91 that will give you a good indication of what a sign must look like. If the brokerage entity is a partnership, corporation, or limited liability company, limited liability partnership, the company sign must contain name or firm of the corporation, name of at least one active real estate broker, the broker of the record, and the word licensed real estate broker. You can look at figure 5.2 on page 92 to see what a sign may look like. Now, anyone who advertises or claims to be providing real estate services is presumed to be acting as a broker. Advertising must inform people they are dealing with a licensee or a brokerage firm. The broker is responsible for all the advertisements must include the name of the brokerage firm. Now, lately, over the period of years, there has been a trend, a new trend in the market where agents have um, created teams and they have decided to work in groups. Now, in the event if agents are working with a team or for a team, with a team, the name or the logo used by one of more licensees must represent they must represent themselves to the general public that they are a part of the team. Now, it also allows broker associates and sales associates to join forces and serve a wider group of customers and more efficiently. Teams or groups must perform license activities under the supervision of the same registered broker or the brokerage. So, in other words, you can't have a team member working for ABC Realty and another team member working for XYZ Realty. So, all the team members have to work under the same brokerage and under the supervision of the same employing broker. An interesting chart. These are the words that may not be used in a team name. Okay. So agency, brokers, limited partnerships, LLP, properties or property, company, associates, brokerage, corporation, real estate or realty. These are the words that are prohibited to be used in a name of the team if you choose to do that. Blind advertisement. What is blind advertisement? It fails to disclose the name of the brokerage firm and includes only a PO box number or a telephone number or street address or so it's illegal. Blind advertisement is definitely illegal. It must be worded in such a way, in a reasonable way, that anyone who is looking at that advertisement should be aware that they are dealing with a real estate license. And like I said, every advertisement must include the name of the brokerage, the name of the licensee's brokerage firm. The key concepts of an advertisements are all advertisements must include the name of the brokerage firm. If a licensee inserts a personal name in the ad, the licensee's last name as registered with the DBPR must also be included. Licensees may use nickname in advertisements provided that they include their last name as registered with the DBPR as well. The brokerage firm's address and phone numbers are not a requirement. Remember this. The address and the phone numbers for the brokerage firm are not a requirement when it comes to advertisement guidelines. Now, there are some exceptions on the internet advertisements, which we will discuss a little bit further in this unit. Now, personal information advertising. Licensees may use their personal name in ads provided into their last name as registered with the DBPR. False, deceptive, or misleading information in any advertisements is illegal. It's considered as a second-degree misdemeanor. Licensees cannot use an association's name or designation unless currently a member in a good standing. So you can't put a name of a organization, let's say ABR, accredited buyer's representative, unless and until you are qualified to do that, you are a member of that organizations. Now, in the event if a licensee chooses to do that, both the broker and the sales associate can be disciplined for false and misleading advertisement. Just talked about it a second ago, internet advertising. Point of contact information is the means to contact the brokerage firm or licensee, including mailing address, street address, email address, telephone, or fax number. Brokerage names must appear adjacent to or immediately above the point of contact information. In other words, you can't have XYZ Real Estate Inc. on this side of the screen and contact John Doe Real Estate Agent on the other side of. They have to be together or adjacent to each other. Now, licensees who sell property by owner, okay, licensees may sell their own property as for sale by owner. They can advertise the property and include personal contact information to reduce liability. It's to disclose that the seller is a licensed before beginning negotiations and in the contract. It's always advisable. Okay. Telephone solicitations. Initiation of a phone call for the purpose of encouraging a purchase or investment property, goods, or service. What is solicitation? By definition, this is what it is. Making cold calls to obtain listings or buyers is telephone solicitation. Now, regulated by the state and the federal law. Calling hours are restricted, and we're going to talk about the do not call list in a little while. The Florida has a no sales solicitation calls registry. The calls are restricted between 8 a.m. to 9 p.m. Remember this, you might see a question on that in the exam. Calls are restricted between 8 a.m. to 9 p.m. Now, it's administered by the Department of Agriculture and Consumer Services. People who are on the for sale by owner properties are exempted. Now, the federal law supersedes the state law. We talked about Florida. Now, let's talk about the federal law. Now, the federal law has a national do not call registry. Okay. The calls are restricted similarly from 8 a.m. to 9 p.m. No exceptions for a FISBO. Okay. So this technically supersedes the Florida law. There is no exception for FISBO. So if you decide to start working, hammering phone calls and cold callings, you must check with the do not call registry. Otherwise, you want to get hit with a $10,000 fine. Florida list is added to the national registry. Now, when representing a potential buyer, you may call a FISBO seller, provided the buyer is interested in this property. You may contact individuals with whom you associate had an established business relationship for up to 18 months after. Okay, so you had a closed transaction, and you can choose to contact them up to 18 months after that business was concluded. You may also contact a customer up to 3 months if at any point they made a business inquiry with you, and that is an exception of making a phone call on somebody who is on a national do not call list. The CAN Spam Act, the Email Electronic Mail Advertisement. The CAN Spam Act mandates that there should be no false or misleading header information on that email. The subject lines must not be deceptive. It must include a physical postal address in every message. Provide ways to opt out of email and owner request within 10 business days. If you're sending out an email, your email must have an option for that recipient to unsubscribe. And if they choose to unsubscribe, you have to honor that request within 10 business days. It must clearly indicate the person or the business who's sending out that email, sending out that message, including the domain name and the email address. The message should identify as an advertisement or solicitation. To learn more about the CAN spam in the FCC website, there is a do not call gov. There is a website, and there is link on page number 97. You will see a couple of links that can take you to the do not call registry and also the CAN spam information. So what's an escrow? Typically in a real estate transaction, when a buyer wants to make an offer on a property, the buyer includes, along with that offer, some kind of consideration to show good faith that they are interested in buying that real estate property. A deposit is made. A deposit is sum of money delivered to the real estate licensee, which is called the escrow deposit. It's a partial payment in connection with the performance of that real estate transaction. It's also called a good faith deposit. Okay, word deposit. It's not something that is transferred to the seller in general, and there are exceptions to it, but in general, it's a good faith deposit that is held in an escrow account. Okay, so escrow account, it's also called a trust account. Okay, it's an account where those funds will be deposited and nobody can access it. Okay. An account for the deposit the broker holds in trust for others. There is a requirement, there is an exception of how much a broker can have in that escrow account of their own personal funds, which we will discuss a little bit in detail as we move along this. But for now, the escrow, the trust account, is an account of deposit that the broker holds in trust for others. Okay. Now, what is a deposit? Earnest money can be in a cash or anything. Typically, it's a check, a cashier's check, or a wire transfer, and it has to be monies which are delivered to the licensee, to the real estate broker in connection with a particular real estate transaction. We'll talk about acceptable depositories. Where can a broker have a trust account? The broker's held trust account can be in a Florida commercial bank, in a Florida credit union, or a savings and loan association. Now, the general practice in real estate, what we have observed in the past many years, that brokers have shied away from maintaining the trust accounts due to accountability, due to liability, potential liability, and then they recommend that the escrows must be held with a title company. Now, in that case, if there is a Florida-based title company or a Florida attorney that's holding on to those funds in escrow, broker is not the escrow agent, and broker is not required to maintain a trust account. So this is a very interesting topic, and you will definitely see some questions on these topics in your end of the school exam and also the state exam. One of those favorite topics for the state. Let's talk about immediately. What does the term immediately means? So sales associate and broker associates, they deliver to their employing broker no later than the end of the next business day. We will discuss the days and the timeline in some of the quiz questions. For now, remember, it's the next business day. Now, brokers have to deposit that escrow deposit that they received from their sales associate or the broker license by the end of the third business day following the receipt by the brokerage. Okay. So as a sales associate, you have to deliver it to your broker by the next business day. The brokerage has to deposit in the escrow account no later than the third business day. Remember these two timelines. So, like we were talking about the timelines, example of an escrow deposit. So a sales associate received an earnest money deposit on Wednesday. Sales associate must deposit to the broker no later than end of business on Thursday. Now, broker must deposit that same deposit in the escrow account no later than Monday, assuming there are no holidays. Wednesday, the sales associate receives is day 0. Thursday is day 1. Friday is day 2. And Monday, broker must deposit. Very easy to remember, great chart to remember. We have a weekend here, and it gives you a good indication of how the escrows are handled. Now, key thing to remember that the escrow check should be made payable to the sales associate. Instruct the buyer to write the check payable to the broker's escrow account. not to you as a sales associate or a broker salesperson. If check is made out to sales associate personally, have the buyer write a new check. Okay. It's not practical to endorse and that check for deposit only to the name of the escrow. That's not acceptable. Okay. You also cannot, as a sales associate, deposit the funds in your account and then write your personal check to satisfy the escrow requirements. That's illegal. It cannot be done. It must not be done. Okay. So remember, in the event, sometimes there may be a situation where your buyer might say, oh, I thought it's going to go to you. No, have them write a new check. The check should be payable to the broker's escrow account. Or in the event, if it's a title company, you can make it directly to the title company. Now, post-dated check. Okay? Uh, let's say there is a situation where your seller is out of town, your buyer is out of town, and he decided to look at some properties and he fell in love with the property, but he does not have the access to to some technology where he can transfer the funds or he has to move some funds, and he wants to write you a check and he is offering you a post-dated checks requesting a few days, or could be anything. In that event, you need to obtain the seller's approval before accepting that. You have to disclose it to the seller that we are having a buyer, we have a buyer who's in this situation, and if it's okay for you, you have to accept, you have to obtain the seller's approval before you get a post-dated checks. Now, in the event if the check is returned because of insufficient funds, broker is not liable. Broker is not responsible. As long as they made the timely deposit, it's the buyer who's responsible. It's the buyer who is in default. So broker is not responsible in that case for any reason if the check is returned due to insufficient funds. Now, for this course, you have to understand, you have to remember that you have the ability as a broker to to maintain escrow accounts, even though that's not a general practice. But you need to be aware the requirements of a broker held escrow accounts. So in the event if the broker chooses to maintain their own account, they must be a signatory on that account. It's a requirement. It's a mandatory requirement. Now, they can have additional people on their manager, their bookkeeper as a signatory, but the broker has to be a signatory on that escrow account. They must be reconciled at the end of every month. That's one of the reasons why brokers choose not to maintain escrow accounts, because of the additional bookkeeping requirements and the liability. And they must review, sign each month every reconciliation statement. Now, if the broker chooses to maintain those funds into an interest-bearing account, uh, then they need to have written permission from all parties and disclose before placing those funds into that interest-bearing account. A part of that written authorization must be who is entitled to that interest. Now, in the event if the broker says that if agreed between all parties, broker may receive the interest earned on that account, on that deposit, but it's up to the mutual agreement of all parties in that transaction. In the beginning, in the initial stages, I told you that there is flexibility of having the broker being able to use their personal funds in the account. This is what we're talking about. Brokers may place up to $1,000 of personal and business operating funds in a sales escrow account. Now, brokers may place $5,000 of personal or business operating funds in a property management escrow. There is a difference. Talk about that a little detail. There is an escrow account for the sales, and there is an escrow account for the property management. You might see some questions on that. For a sales escrow account, the figure is $1,000. Now, on a property management escrow account, the allowed amount to use broker's personal funds is $5,000. Now, these are the funds that are placed in the account to maintain the operation of the account, and they are not considered as commingling of the funds. They must be accounted for in the broker's monthly accounting records. As we move further into the course, we will have some math problems where you will be able to identify how to do the reconciliation, and there might be some questions where a broker will be using their personal funds into maintaining their escrow account. So you'll come across that in the later part of this course. Brokers must keep their business records, books, and accounts in compliance for the DBPR. They must preserve the record for 5 years and 2 years beyond any court proceedings. Okay, 5 years and 2 years beyond any court proceeding. Now, mishandling of the escrow funds, the management of the escrow fund, mishandling. The unauthorized use of another person's funds or property for one's own use is considered as mishandling, conversion. So, an example is a broker transfers $1,000 from the escrow account to the general business account to pay an office maintenance repair. That money doesn't belong to the broker. That's a trust account. That's a money related to an escrow deposit for any particular transaction. That money does not belong to the broker. So that qualifies as a conversion. Now, brokers may also not use the earnest money for their personal or business expenses. Trust funds must be kept in a separate account until the transaction is closed. Another word that we will be using, we come across, is a commingling. Now, the definition of commingling is to mix the money or other personal property of another with the broker's own money or property. In this case, the example is the broker receives an earnest money deposit of $5,000 for a pending transaction on a listing. Broker deposits that $5,000 in a general operating account that are used to pay business expenses. Now that's considered as commingling. The other one was conversion. This one's commingling. Now, it is a big violation of the license law. So remember, that should not happen. Another part of mishandling of the escrow funds is failure to account and deliver, licensee's failure to deliver the money, legal documents, or commissions to persons. In that example, broker received a check from buyer made out to John Stetson, attorney trust account. Broker placed the check in a desk drawer, intent to deliver next day to the attorney's office. The closing statement failed to show earnest money from the buyer, and the attorney had no record of the deposit. Now, that also is considered as a violation of license law. It was not commingling, it was not conversion, but it was failure to account and deliver. That also constitutes as a violation of license law. Now, title companies, attorney escrow accounts, that's general practice that we talked about. Um, Indicate the title company's or the attorney's name and address, telephone number on the contract. The FAR bar contracts that are generally widely used by members of the National Association of Realtors have a very clear indication of where the monies are going to be handled. So pretty much at the time of the contract, at the time the offer is being negotiated, the general practice is the name of the title company or the name of the attorney or the third party escrow agent is already declared, already disclosed. Within 10 business days after the deposit is due, buyer's broker must make written request to the title company or the attorney for a verification of the receipt of the deposits. Okay? Within 10 business days after broker made the written request, seller's broker with a copy of the written verification as well. Now, In our real estate business, there are situations, there are scenarios where you might run into escrow disputes, where both parties are not having a meeting of minds. They do not want to proceed with the transaction. At the same time, they do not want to release the escrow money to each other. Now, that is not a good situation to deal with, but we have to. It's part of our business. It's called conflicting demands. So, whenever there are two parties which are not agreeing, then we call it a conflicting demand. And the Florida Statute 475 provides the dispute resolution process when there is a conflicting demand between these two parties. Good faith doubt. What's a good faith doubt? It's a scenario where the broker doubts either party's intention to act in good faith and according to the contract. In that case, it's broker's obligation to notify the FRAC in writing within 15 days of having such doubt. If the broker is feeling, if they have a doubt that no, they are not acting in good faith to move forward with the transaction, and they have to begin a settlement procedures within the 30 days of having such doubt. Okay, 15 days to notify the FRAC in writing, and 30 days of having the good faith doubt. What are the examples of a good faith doubt? One of the examples that we can say is the transaction date has closed, has passed, and the broker has not received um, any instructions from the buyer or the seller regarding how to disperse. The transaction closing date has not passed, but one or more parties have expressed the intention not to close, and brokers have not received identical instructions from the buyer or the seller as to how to disperse those escrow deposits. The Florida Statute 475 offers dispute resolution procedure. It's called the settlement procedure. A broker is required to follow any one of the four settlement procedures that we're going to discuss within 30 days of receiving the conflicting demands. Okay. The time periods run concurrently. So, in case if the broker decides or if the broker wants to wait 10 days before taking any action, then he only has 20 days left to follow the settlement procedures. Okay, so timelines are very important with this. The settlement procedure, and you can remember this with a term MAIL, mediation, arbitration, litigation, and escrow disbursement. Go through the process, explain it to you in a second. So the mediation, what is a mediation? It's a informal, neutral party negotiated settlement procedure. Okay, happens a lot. Happens a lot where there is a third party mediator. Then you can sit down with them, and they go through. They listen to both parties. Typically, either you can sit down together or you can sit down. Whatever the situation is. So mediation is more informal. Okay. Now, the arbitration. Now, prior to getting into the arbitration, uh, all parties have to consent that the judgment is going to be binding on both parties by third parties. Okay. Now, the litigation, which is the more formal, way of fighting against the claims. Interpolated broker has no financial claim. Uh, the judge declares each party's rights to the funds. So that's pretty much binding as well. And then the last procedure is the escrow disbursement order. Now, the EDO is also one of the settlement procedures. Let's talk about the Now, the broker may request the commission, the Florida Real Estate Commission, to issue a escrow disbursement order. In that case, the FREC makes a determination who is entitled to this disputed money, and now, apart from the three procedures that we talked about, the mediation, arbitration, and the litigation, the broker also have an option of requesting the commission for an EDO, which is called the escrow disbursement order. Now, in that case, if the broker is requesting an EDO, the FREC makes the determination. The Florida Real Estate Commission makes the determination of who is entitled to the disputed amount. As long as they're being held in the broker's escrow account. Okay. If the monies are sitting in a trust account with an attorney or a title company, FREC does not have jurisdiction on that. EDO procedures are available if the disputed deposit does not exceed $50,000 and the funds are held in the broker's escrow account, like I said. The brokers must notify the FREC within 10 business days if the dispute is settled between the parties and if the matter goes to the court before an EDO is issued. Timelines are very important. If the licensees promptly use one of the above escape procedures and act legally and not comply, may file against them. Okay. If the broker promptly use one of the procedures and follow the resulting direction, the broker is exempted from any disciplinary action. Now, there are some exceptions to the notice and settlement procedures. Now, sale of HUD-owned properties comply with HUD contract. Timely notice of right to cancel a residential condominium contract. Failure to satisfy the financing clause in the contract also qualifies as an exemption. Title company and attorneys as an escrow agent. We've been talking about that. In that situation, just like I said, brokers have been shying away from maintaining escrow accounts in the recent years due to the additional bookkeeping and liabilities. Broker is not obligated to report an escrow dispute to the FREC. Okay. They're not obligated to institute any settlement procedures. The title company and the attorney will not disperse funds without authorization from the parties. Okay. And if none of that works, it will be decided in the court of law. Sales Associates Commission. Now, sales associate commissions must be paid by the employer. So if you practice real estate, and you have to remember that the commission earned belongs to the broker, and the broker is your employing broker, and they are the ones who are going to issue you your commission depending upon what your arrangement is with their particular brokerage. They are not paid directly by the buyer or the seller. The split, like I said, is determined between the broker and the associate, not the buyer or the seller. Now, associates may not operate independently. All listing, contracts, commissions legally belong to the property of the sales associate's employing broker. Remember this. You cannot accept any funds from any parties. All the monies have to be dispersed to you as your commission from your employing broker. Now, the broker's commission is established by the agreement between the broker and the party who agrees to pay. It's negotiable. Okay. State of Florida does not regulate any commission rates or fees. Okay. You can choose to work for any figures as long as it's negotiated and in writing between the party and you. Now, licensees may choose to share your commission with the buyer or the seller as long as it's disclosed in the transaction. It happens very commonly. You're working with a friend, you're working with the family, and you choose to contribute X amount of dollars, a portion of your commission. But as long as you are disclosing that on the real estate transaction, then you are good to go. Okay, you can't have any side arrangements. You can't accept the money from your broker and then write them a personal check outside the transaction. That is an illegal way of contribution. Let's talk about liens on residential property. Now, if there is a situation where there is unpaid sales commission and the broker feels that they deserve the commission, only brokers can seek compensation from the buyers or the sellers. Okay. There is a way of putting a lien on the residential property for non-payment of commission, only allowed if the broker is given that authority in the listing contract. So your listing contract must specify if there is an ability for the broker to put a lien on that property in the event there is an unpaid sales commission. If the listing agreement does not give you that flexibility, does not give you that authority, then you have to go and seek civil judgment against your client. And you cannot encumber the title to real estate property. Okay, that lien cannot be a cloud to the title to the real estate. So let's continue with the Commercial Real Estate Sales Commission Lien Act. Now, it's a part of the Florida Statute 475, Part 3. It gives the brokers lien rights to the seller's net proceeds from the sale of any commercial property. Remember, we're talking about commercial right now. Now, these are not the lien rights to the real property, but only to the net proceeds which are coming from the sale of that real estate. Okay. Let's talk about the unpaid real estate commission on a transaction. Now, it may happen, once in a while where there is some misunderstanding, there is a disagreement between the client does not want to pay the real estate commission to the broker, and that may occur. Now, you have to remember that the law gives permission only to the broker to go after the buyer or the seller for their commission. You, as a salesperson, cannot do that. You still have to go back to your broker and have them pursue the procedure to go after the client for the unpaid real estate commission. So moving forward now, we're going to talk about the Commercial Real Estate Sales Commission Lien Act. Now, Florida Statute 475, Part 3 gives broker the lien rights to the net proceeds from the sale of that commercial property. Remember, these lien rights are only against the net proceeds, not the real estate property. Now, the brokerage agreement, the listing agreement, must clearly indicate about the broker's liens, right? And once you get into the practical real estate business, you will be going through those listing agreements, and each brokerage have their own set of languages that they go after. Now, if you pay attention to the figure 5.7, which is on page 111, you will see the key points regarding the difference between the residential and the commercial lien rights. So on the residential side, broker cannot place a lien on the real property unless owner gives express authority in the listing agreement, buyer's representation agreement, or sales contract. So broker cannot just by default automatically go ahead and put a lien on the property unless and until it's specified in the one of these agreements, like I said, the listing contract, listing agreement, the sales contract, or the buyer's representation agreement. Now, on the commercial side, you'll see broker must include in the brokerage agreement the required disclosure regarding the broker's lien rights on or before the time the owners enter into the brokerage agreement. So on the commercial side, it's a little different. The broker has to disclose what their policy is about Brokers Lien Commission Act. On the residential side, unless a lien right is authorized, the broker must seek relief in a court of law and obtain a judgment for the amount owed. Okay, that's for the residential. Now, for the commercial, if the disclosure is included in the brokerage agreement and signed by the owner, the broker has the lien right on the owner's net sale proceeds for any unpaid commission. So here's a big difference. On the residential side, even though it's been in writing, the broker has to uh, go in the court of law and obtain a judgment against the owner of the property. Versus on the commercial side, if you have documented evidence that you had provided the required disclosures, then automatically you qualify uh, for the owner's net sales proceeds and the lien against it. Let's talk about kickbacks, an important topic, and you might see some question on your school exam or your state exam about it. So what's a kickback? The definition of a kickback. A kickback or rebate is an unearned fee paid to a licensee associated with a real estate transaction for non-real estate services, payments for something other than the real estate service. Kickbacks are legal under limited conditions. Okay, you have to fall into certain do's and don'ts, or guidelines, whether that kickback is legal or not. So we're going to go over a list of important facts about the kickbacks and the rebates. Okay. Now, referral fees for non-real estate services, buyers and sellers must be fully informed. So in the event if there is a situation where you as a salesperson are receiving uh, any referral fee, or you're in a transaction where you are paying a referral fee to a third party, a third real estate agent or broker, then all parties, the buyers and the sellers, must be fully informed. That referral fee must be disclosed to the clients. Second important part is it must not violate RESPA, okay, the Real Estate Settlement Procedure Act. You cannot pay an unearned fee associated with the closing services. Okay? Person receiving that referral fee must be properly licensed, a mortgage originator license or a real estate license. We're talking about real estate right now. So you have to remember you cannot pay a referral fee to an unlicensed person. So a great example is that your local convenience store guy that you go on a regular basis, and all of a sudden he has a friend or a family member who wants to buy or sell real estate and refers that clients. And if he is expecting anything in return, all you have to say is thank you. You cannot provide them any kind of a monetary compensation or referral to an unlicensed person. Before we move forward to the chapter 5.7, let's knock out these couple of practice questions 25 and 26, which are on the page 112 of your textbook. So the brokerage business entity. Okay, let's talk about what type of entities are allowed to operate as a real estate brokerage. Florida Statute 475 defines brokers to include anyone who is in general partner, officer, or director of a brokerage partnership or the corporation. A broker may choose a variety of legal entities. If you pay attention to the figure in your textbook, 5.7, page 112, you will see an image that gives you descriptions about the type of business entities that may be registered to operate as a real estate brokerage. Now, at the same time, you will see in that same image, there are types of legal entities that are not allowed to operate as a real estate brokerage. It's an important image, important. You might see a question on this topic in your exam. I recall seeing that a lot. So, now, the business entities that may register as a real estate brokerage are sole proprietorships, general partnerships, limited partnerships, limited liability companies, corporations, and LLCs. Okay. These are the type of legal entities that you can go and register as a brokerage with the Department of Business and Professional Regulations. So we'll talk about briefly what type of entities are structured. So a sole proprietorship is owned by one person. Okay. Many real estate agents who are brokers actually, they're not aggressive. They're not too actively involved in the day-to-day operations and sell. So for them, they feel it's much easier, simpler to operate as a sole proprietorship. Um, so technically, it's the business is registered in their name. So John Smith is a real estate broker, and he would be practicing real estate under his trade name. The downside about sole proprietorship is that the owner, the broker, is personally liable for any issues, any damages that may occur in the operation of that business. Okay. Partnerships, general partnerships. A partnership is formed when two or more people engage in a business together. Okay. Uh, Typically, there is a partnership agreement, in which dictates the terms and conditions of the operation. So the real estate brokerage general partnerships, the partnership must register with the DBPR under the partnership name. At least one of the partners must be an active broker. Partners who will deal with the public and perform services of real estate must be licensed as active real estate brokers. So there may be a situation where you have partners who are not licensed real estate agents, but they are your business partners. You can definitely choose to make them your business partner. But when it comes to day-to-day operation of the real estate services, real estate brokerages, the responsibility of practicing real estate is for the active licensed real estate broker, and of course any employed salespersons or broker associates. Now remember this, it's an important thing to remember. You might see a question on this. Sales associates and broker associates are not allowed to be general partners in a real estate broker partnership. So by default, you have to remember, if you have a real estate license, you cannot be a partner, you cannot be an officer of that corporation, which is registered as a real estate brokerage. Now, in the partnerships, we talked about the general partnerships. Okay, now we're going to talk about, let's talk about limited partnerships. We did talk about the general partnerships, but now let's talk about the limited partnerships. They're created by a written instrument that's filed with the Department of State. It has to have at least one general partner who's responsible for the dealing with the general public and practicing real estate and performing the real estate brokerage services. On the other hand, limited partners are more like silent partners. They're not involved in the services of the company. They don't contribute to the services. They contribute towards making an investment, a contribution to the company in terms of a property, but really not providing services. They have very limited liability because it's the word limited. At least it's just like a general partnership, The limited partnership must register with the DBPR under the limited partnership name. The general partners who will deal with the public, perform services of real estate, must be licensed as an active real estate broker. At least one general partner must be licensed as an active real estate broker. All other general partners, their names and addresses are disclosed. They must register with the DBPR for identification purposes. Okay. Now, sales associates and broker associates may not be general partners in a limited partnership organization. However, they can be limited partners. So a limited partners is pretty much treated like a stockholder in a corporation. So as a salesperson or a broker associate, you are allowed to become a silent partner, a limited partner in a real estate brokerage, which is registered as a brokerage limited partnership. Now, just like a limited partnership, there is another entity which is called a limited liability partnership. The partners in an LLP enjoys protection from personal liability. So, as we go in details, you'll be able to distinguish between the different types and which suits which person, and that's why the law gives you the flexibility of operating under different organization, different types of business entities. The partners in a limited liability partnership enjoy protection from personal liabilities as much in the same way as limited partners do in a limited partnership. Now, limited liability partners are not liable for obligations or liabilities of the partnership arising from the contracts, errors and omissions, negligence, malpractice, or wrongful acts committed by another partner or an employee, agent, or representative of that partnership. So the next entity we will talk about is corporations. A corporation is almost like an artificial person or a legal entity that's created by the law. In order for a real estate brokerage to operate as a corporation, it's required to file articles of incorporation with the Department of State, regardless if it's a local corporation or a foreign corporation that's registered in another state. It is allowed to operate in the state of Florida to practice as a real estate brokerage. In corporations, the owners are more like stockholders of that corporation, and it's managed by a board of directors and officers. It's a very structured way. Now, the corporations may be registered as a for-profit or a not-for-profit as well, depending upon the scope of the business. The corporation must register with the DBPR under that corporation name. At least one of the officers or directors must be licensed as an active real estate broker. Active real estate brokers, inactive real estate brokers, and unlicensed people may serve as a officer and directors of that real estate brokerage. However, officers and directors who will deal with the public and perform services of a real estate must be licensed as an active real estate broker. Okay. All officers and directors who are not licensed, okay, remember this, all officers and directors who are not licensed, they must be registered with the DBPR for identification purposes. This is accomplished by submitting each individual's name, residence address, office held, their position in the company, and the percentage of ownership. We're completing the management and information section of the brokerage corporation application. Inactive brokers and unlicensed individuals. Inactive brokers and unlicensed individuals may perform managerial functions for the brokerage corporation that do not involve real estate functions such as administrative matters, bookkeeping, accounting duties, more like on the admin side. Sales associate and broker associates may not be an officer or a director in a real estate brokerage corporation. Remember this. Sales associate and broker associates may not be an officer or a director in a real estate brokerage. A sales associate or a broker associate may be issued a citation and fined for serving as an officer or director of a brokerage corporation. Okay. Sales associate and broker associates may become shareholders of that corporation. Okay. So it's a kind of like the limited liability partnerships. Uh, the one of the most commonly used entities that has gained a lot of popularity in the past few years is the LLC, the Limited Liability Company. The reason it has gained a lot of popularity is it has pretty much all the protections, all the features of a corporation and a partnership. At the same time, it has very fewer requirement when it comes to the operation of the LLC, filing requirements, and the day-to-day operation. Uh, it provides the owners the flexibility, the protection from personal liability against the business debts in the same way the corporation does. Income is taxed only once, as in a partnership. An LLC has great flexibility and is how it passes the income and deduction as members. So limited liabilities companies are formed in Florida under Chapter 605 Florida statutes. Okay. So that has gained a lot of popularity lately. Let's quickly talk about the vacancies in the office. If an active broker of a brokerage entity dies, resign, or is unexpectedly unable to perform its duties as an active real estate broker, the vacancy has to be filled within 14 calendar days. 14 calendar days, remember. During that transition, when the brokerage is without a broker, no new brokerage business may be conducted until a new active broker is registered with the DBPR. Now, the failure to timely report that replacement of the broker may result in the cancellation of the registration and the licenses become involuntarily inactive for the company. Temporary broker. Now, vacancy of the office may be filled with a temporary broker. It must be registered with the DBPR temporary broker for up to 60 days without need to comply with the DOS registration requirements. Failure to appoint an active or temporary broker within 14 days deadline results in the automatic cancellation of the brokerage's registration. Remember, it's very important. Need to have a broker on record, whether it's permanent or temporary. It needs to be there in order for the brokerage to operate as a real estate brokerage. Okay. So we did talk about all the different type of legal entities that may register and may operate as a real estate brokerage. Now we will talk about the entities which are not allowed to operate as a real estate brokerage. Okay, they may not register. Okay, so there is an ostensible partnership. It's also called a quasi partnership. So the definition is an ostensible partnership is not intentionally created, rather than the conduct of two or more persons create the appearance that a partnership exists. Okay. It's considered fraudulent and deceitful. So you have to be very careful when you are practicing real estate. If you're practicing real estate in partnership with another person in a joint venture, and you're collectively working together, but you don't have a legal agreement, legal arrangement between the both of you, but it may appear to a general public that you are partners. Now, that may not be a situation where you are allowed to register. Okay. A corporation sole, remember this, you might see a question on your exam about this. A corporation sole is a nonprofit entity that's designated to ensure continuity of ownership of a property dedicated to the beneficiary of a religious organization. Okay. So difference between a corporation and a corporation sole. It's a nonprofit religious entity. It's not allowed to register as a real estate brokerage. Joint ventures, okay? Just like I said, broker A wants to work with a client, broker B, and you guys are working together, you have worked out an arrangement as to how the compensation will be split between two of you. It's a temporary business arrangement. Two separately registered brokers may conduct real estate business as a joint venture, okay? But it cannot be registered as an individual entity. A business trust, okay, involves entities' own property. A business trust is a form of business entity that may be created in engaged transaction involving its own property. A business trust is formed by any number of persons who make an investment for stipulated amount per unit. Okay. Cooperative associations, corporation-owned property. Okay, they don't. There are some in Florida, but they're more like a corporation. So instead of you owning the property, you are actually a part of that corporation. You buy the stocks into that corporation. That's why you don't get legal title to that property, and that's why those are not financeable. Very, very few creative lenders will be able to get you financing. So whenever you see a property which is a cooperative association, you will see that generally they ask for cash only sales. Trade names, fictitious name. Now, the Florida laws allow you as a real estate broker to register a fictitious name for your business. So we have a company, ABC Realty, but you want to practice as a Gold Key Real Estate Services. So your corporation name, your legal name would be ABC Realty, but you want to practice as a Gold Key Real Estate Services. So you will have to register that as a DBA, which is a doing business as. Now, fictitious name have to be registered with the Department of State. Brokers who operate under that trade name must also register their trade names with the DBPR. So the DBPR has to be notified about your entity, the brokerage entity. At the same time, it has to be notified about your DBA, your doing business as, your trade name, your fictitious name. Now, sales associates, remember this, might see a question like that. The sales associate cannot register under a trade name. They have to have their licenses issued in their legal names, okay? Now, for tax purposes, the Florida law allows a sales associate to register a professional association in their legal name. So a sales associate may not be able to register, may not be allowed to register themselves as a trade name, but they can form a PA, which is a professional association in the associate's legal name. They may organize themselves as a PA in their legal name only. So if it's John Doe, the PA is going to be John Doe PA. It has to be registered with the Department of State. Uh, the DBPR has to be provided a proof that the PA, the professional association, has been registered with the Department of State. Okay. Uh, So there are a few examples of how they can be registered. One of them is a professional corporation. The other one is a LLC, again, limited liability company, and professional limited liability company at the same time. Okay. You might want to consult your tax accountant, your tax advisor, as to see what might be the best option in your particular situation if you decide to go that route. So, moving forward, let's talk about personal assistants who are personal assistants, and they are hired to perform pretty much the administrative and the clerical tasks of your business. They may not perform the duties of a real estate licensee. They cannot be paid a commission. Remember this. A personal assistant cannot be paid a commission. Any licensee who employs an unlicensed assistant, they must comply with the state and the federal employment laws. Okay. Remember, you cannot pay them a commission, and you have to abide by all the federal and the state employment laws if you decide to hire a personal assistant. Now, at the same time, if you hire a licensed person, a person who is not actively practicing real estate, but they do have a real estate license, they are the ones that can perform real estate services with you or on your behalf. They have to be registered with the same employing broker. So if you are salesperson A, you cannot have a licensed salesperson who is working with another company, who's working with another employing broker. Okay. Now, broker must be the person who pay the license assistant for brokerage activities that require a license. So, in other words, all compensations for that license assistant must come from the broker rather than the salesperson. So pretty much this concludes our chapter unit 5. There are a few practice questions on page 119. Let's knock those out and see you in unit 6.